All right, we're continuing our series on contract basics. This is video number 4. And in today's video, we're going to discuss contract non-performance. We have contract non-performance. So there may be several reasons why someone does not perform on a contract. Now understand what I'm talking about here is, in the case of a purchase agreement, the purchase agreement has been agreed to by all parties. It's a bilateral contract, so it is binding on everybody. All parties are expected to perform all the way to closing, but for whatever reason, one party does not perform or they don't follow through with the terms of that contract. And there are some reasons that we need to know that can impact substantially the real estate transaction. So the first one I talk about is what happens if there's property damage. Now, it depends on the extent of the damage, but typically, if it's substantial, then the contract it's done. It's terminated. And typically what happens in purchase contracts is the language within the contract will outline what happens in certain scenarios. What happens if it's minor damage and there's an insurance claim? What happens if it's a total loss? Who sustains the damage, those type of things. So the contract is going to spill out typically what happens in the case of what if. All right. The next one is death. Well, death can impact the contract, but it depends on the type of contract that it is. So for example, if it's a listing contract and the property is not under contract with a purchase contract or encumbered by a purchase contract yet, then the contract dies. A listing contract dies at death. Now, if there was a listing contract and a purchase contract, it changes, and then it kind of depends on the parties. So if the buyer dies and the buyer was required to they were using their income to get a loan, then obviously the deceased party isn't going to be able to perform because they will not be able to obtain financing. Now, if the deceased buyer has substantial assets within their estate, then the seller could make a claim and say, listen, your estate needs to take things over. But typically that's not what happens. Typically what happens is if a buyer dies, the contract dies because there's financing. If it's a cash deal, though, that could totally change the ball game. What about the seller if there's a purchase agreement in place? And that depends again on how quickly it's going to close. But typically the buyer is going to expect the seller's estate to perform. All right, so that's typically what we see with death. Now, I do want to talk about something else here because I have been told by a couple of students that have taken the exam, they asked a scenario about death, but it was regarding a lease agreement. And typically what happens in a lease agreement, if the landlord dies, nothing happens. The estate of the landlord is going to have to fulfill or complete the terms of the lease contract. Typically what happens with a tenant is technically, I suppose, the landlord could go after the tenant's estate and require them to perform, but typically that's not the case. They don't have the finances in the estate, and so upon death, it typically will terminate. All right, so, all right, a rescission. What we're talking about here is mutual consent. Happens all the time. The buyer and the seller just simply say, we have had enough of each other, and they both just agree to part ways. And sometimes that also happens with property management contracts between the owner and the property manager, as well as the landlord-tenant. All right. The next one is partial performance. Now, this is common as well. So one party fails to follow through with some or all of the terms of the contract. And I'm not going to go into too much detail here, but there is one remedy that I do want to discuss. And that is if the injured party always has a right to due process, meaning if the other party breaches, they have a right to go into court to settle the dispute. And they can sue for damages and monetary damages and whatnot. But there's one that I want to talk about, and it's a key real estate term that you have to know for your real estate exam. And that is specific performance. And it is what it sounds like. The injured party is going to ask the court to enforce a specific remedy or they're going to ask the court to require the other party to perform specifically. And I'll give you an example of what that means. So let's say that there's a purchase agreement in place and the seller just simply decides that they don't want to sell the house. And the buyer says, well, that's not okay because we still want the house. No one can force the seller to sign the deed at closing or even appear at closing. So the buyer could go to court and sue the seller, and a judge could require, under specific performance, the seller to pass title to the buyer. The seller could technically do the same thing, where the buyer just simply says, listen, I'm not going to buy it, I've changed my mind, and then the seller goes in and forces the buyer to perform and buy the house. I will tell you, I've been doing this real estate thing for over 20 years, and I've never seen where a buyer has been required to purchase the house, but I have seen where a seller is required to pass title. Now, sellers typically go in and sue for damages, financial damages that they've suffered, and those type of things, but I've actually never seen a judge award specific performance against the buyer. It could happen, but I've just never seen it, all right? Specific performance. Now, the other thing I want to talk about is what we call affirmative defenses. So let's say that they had a purchase agreement in place, and for whatever reason, one party doesn't perform, closing is missed, and then I don't know, everybody starts suing each other. Well, there are some certain affirmative defenses that a defendant, who is the party that's being sued, can claim. The first one is what's called statute of limitations. Every state has statute of limitations depending on what it is. So in criminal law, certain crimes, if the prosecutor does not prosecute the defendant or the suspect within a certain number of years, then they cannot sue or they cannot bring charges at all. Common statute of limitations for contracts is 4 years. So if you're in a state that has a 4-year statute of limitations, that simply means that the injured party has to bring suit against the other party within 4 years, because if they wait too long, then the defense is, the other side's going to say, listen, even if they had a claim, they waited too long to file the claim against me. The other one is Latches. This is an old common law defense. It simply means that even if there was something that happened that did warrant a lawsuit, you waited too long to file. You just simply waited too long to file. I'll give you an example. Let's say that house closes and the buyer discovers that there's something wrong with the air conditioner, but they wait 10 years to file suit against the seller. Well, the seller is going to say, listen, even if there was something wrong, you waited too long to sue me. And that's the doctrine of Latches. So that pretty much sums up the defenses and the contract non-performance for this video.